Good evening, everyone. Hello and welcome. Today we have a very special guest, Mr. Arun Shourie, who he has just recently written his latest, I think it's his 29th or 30th book, titled The Commissioner for Lost Causes. And being a legal website, we've taken a special interest in all his writings from, I think from 2001, you wrote courts and their judgments.
Yes.
And so we've gone through about 4 or 5 of his books and writings, and we've come to better understand his views and perspectives. Thank you for being here, sir.
Thank you.
So we'll start with the first question. So as lawyers and officers of the court, we view the court and their judgments in a very deferential manner, holding judgments as sacred and using them to build our arguments and serve our clients' interests. Therefore, most of the time we may not view judgments with a journalist's lens. So this was evident from a reading of the chapter that recounts the anecdote involving Justice Bhagalpur following the S.P. Gupta judgment, which is the first judge's case. Because not only have you applied a compare and contrast analysis you have a part called consistency, and you use all his past rulings to see how they apply in the present. But you can also apply the political context, because it related to the affirmation of O.N. Bora, who also was involved with the Kissa Kursi Ka case.
Yes.
And in addition to that, what his equation with the chief then Justice Chandrachud was. So all these factors become very important, which lawyers will never sort of examine, but it's that lens which I don't think in the present day and age there's many people who are applying that to the court's judgment. So what do you believe should be the guiding tenets of legal journalism in evaluating as opposed to reporting events emanating from the legal sphere?
That's a very important point. I feel that one of the great contrasts between let us say US jurisprudence and Indian jurisprudence is that we don't examine the judgments out of fear, out of this rationalization, oh, I may offend the judge and thereby my client may suffer. That's a rationalization. But in America, when a judge comes up for confirmation, let's take to the appeals court or to the Supreme Court, and just see how much work has been done on his judgments by the American Union for Civil Liberties, for all sorts of other interest groups. So everybody is well armed about that judge. Of course, much of the questioning as recently happened is absolutely partisan and outrageous in the Senate committee. But that does not mean that the judgments were not analyzed. And the judges therefore are very conscious that we are under scrutiny. That is very important. Here, the judges, I fear, are very complacent, that nobody is really going to question them.
Yes.
And therefore, the question of consistency, facts being ignored, as Justice Gogoi and Justice Kaul and to my great surprise, Justice Joseph, in the Rafael hearings
Yes.
and matter, it was astonishment, and nothing like that could ever happen in a country where the judges knew that they are being scrutinized. So I think scrutiny is very important, and the best people to do it are not journalists but lawyers, because they are trained in the law.
Yes, sir.
But they are the most reticent.
Yes.
So I fear that this, and that is actually leading to an incestuous relationship between some seniors and some judges,
Yes, sir.
which is not a good idea.
Yes, sir. You just mentioned about looking more into the facts of the case, right? The duty of the judge, and you'd mentioned the same in a recent interview with Shekhar Gupta as well. But however, especially in the case of Aravali mining and all that, right? So the judge's duty to look more into the facts rather than just the technicalities. How does this go in line with how overworked the judiciary currently is?
Yes, I'm sure you are absolutely right. They are terribly overworked. I mean, I'm astonished how they can write judgments as long as my articles, so as long as my books, but they do, and they really must be working very, very hard, and with almost at that time almost no assistance, and today just minimal assistance. Therefore, we must provide them much more assistance, and we must, as the Chief Justice has again said, it is criminal to allow vacancies to persist.
Yes.
And therefore, we must have a system. I do not think that the executive is the right body to sit in judgment on what the collegium recommends. Of course, the collegium should not be a bargaining group. That what Justice Verma and others also in the end were emphasizing. But even so, it is better, as Lord Denning will say, you have to trust somebody, might as well be the judges.
Yes.
So it is best that their recommendations on their appointments and on the need for infrastructure, on the need for more judges,
Allocations.
and on the need for, let's say, just recently retired judges being made ad hoc judges, we must accept these. Because otherwise we continue in the present situation. I can give you from personal example, by personal experience, of how terrible the process today is. And nobody seems to care.
We saw that in the first chapter.
Yes, but now actually in the next edition of that book, I'm going to write Anita gets bail, and the subheading is now going to be, and so do I. Because some judge in Jodhpur has issued non-bailable warrants against me.
Oh.
And now that is going on for 1.5 years,
Okay.
and probably 12 hearings, and 4 judges have recused themselves from the case, and the case has gone probably to 7 judges, and the last 3 occasions the hearing could not take place because, for very good reasons, the Union of India has intervened to say that this is a faulty order, defective order, etc., and should be struck down. But they have to be represented by the Solicitor General, who is also as overworked as anybody else.
Definitely.
So he could not come. But I can tell you that in 2 of these episodes, these were on dates on which my wife was, 3 of these episodes, my wife was in the ICU. She was on a ventilator. I was living in the ICU. I was not coming home. But I had to create a vacant room in the hospital so that I can attend the hearing virtually. And in the end, it was not heard. Or it was said that no, it adjourned because the Solicitor General cannot find the time today. So I said, and I told the learned judge, she's a very fine judge, it's obvious she's very alert. And I said that next time also he will be busy. And exactly the same thing happened. So now it is that she was very good, and she said that all right, then we'll fix it for the 25th of May, so that the Supreme Court is on vacation.
Yes.
But there will be the vacation judge, vacation bench. So
Yes.
So the process is terrible.
So going back to your book, and because I had always heard of the Bhagalpur blindings. I just, as a in all our general knowledge, all the preparation tests, etc. This event is historic, so everybody reads about it. But it was the first time I read a proper account of both the under trials case as well as the Bhagalpur blindings case. And I think because we have a very young audience, I'm not sure everyone is very familiar, and I think it's very important to recount that. So I would like, there was a lot of stakeholders. I'm sure the Express was the driving force, but you say that it was on, I think, KF Rustamji's reports, and there's a lawyer, Mrs. Hingorani.
Mrs. Kapila Hingorani, yes.
So if you could just give us a brief snapshot.
You see, Mr. K. Rustamji was a very distinguished police officer. He was the head of the BSF. He had a lot to do with the creation of the Mukti Bahini in Bangladesh. And Then the National Police Commission was appointed. I think Mr. Dharamveera was the head of it. Mr. Rustamji was one of the members. And he used to go as part of the tours of that, and he would write tour notes. And a few of us were he was so kind that he would send them to us. So these, there were 2 tour notes of his on what he saw in jails. And that certainly caught my eye. So I published those notes, and then we coordinated, all of us, with our state correspondents, that they must each of them visit a jail and prepare information on the following points. So that then it was a process of collating, and they went and they were. So it led. Mrs. Kapila Hingurani was a very public-spirited lady, and she took up these matters to the Supreme Court. Justice Bhagwati was shocked by the material, and he gave far-reaching orders again and again. Eventually, we were told at that time that, I think actually Justice Bhagwati told me that on his estimate, 40,000 people had been released as a result of those judgments.
Yes.
And then in the Bhagalpur blindings, it was a terrible thing. In the under trials cases, you see, there were persons who had been there maybe twice or thrice the time that they would have had to spend in jail if they had been convicted of the crime which they had been alleged to have committed. In the Bhagalpur blindings case, it turned out our one of our best reporters, Arun Shourie,
Yes.
who was our reporter in Patna, he learnt, and he went to Bhagalpur, that there almost an industry had been set up in which a person whom the police regarded as an undesirable person was caught, and he was laid down, and with this long needle which was used in those days to stitch the gunny sack, his eyes would be pierced by a doctor, and both eyes pierced, and then to make sure that he had lost sight completely and could not recognize anybody, acid was poured into those injured eyes,
which they called Ganga Jal.
Ganga Jal, yes.
True.
And but given the condition of the Ganga now, it may be true. So Arun, and he was helped in this case by a very conscientious jailer, Mr. Das, and he would allow access to him and so on. And Arun did a series of reports on this. We displayed them properly and followed it up in many ways. And that matter was also taken up in the Supreme Court. And again, Justice Bhagwati was absolutely astonished that this is happening in this society. And so that also led to a number of judgments. And unfortunately, the net result was that the jailer was dismissed. And Mr. Das.
Right.
And his petitions for reinstatement, for some compensation, all rejected. That this is not the proper way, etc. for him. And on the other hand, those poor blinded people were given a pittance as compensation per month. And when I was writing this, I requested Arun last year to please contact. There was a local lawyer in Bhagalpur who was following up their cases.
Still,
to the day. Yes, many of them have died. And he told us that even they are not receiving even that little compensation. I mean, such is the cruelty in our society. Anyhow, that was a very great investigation by Arun Shourie.
That's the ironic part, that these are such great things, I mean, in public interest that have been achieved and that are there in the annals of history. But at the end of the day, the net result, I think in the under trials case, there was to be a census every 2 years.
2 years.
Maybe that happened once,
Yes.
and then it was never followed up. And I'm sure you use this phrase that the Hope and Trust School of
Yes, that was Justice Bhagwati's phrase.
Correct.
It almost became, it was just the Hope and Trust. That's one of the very, very important points which I would plead with the judiciary. You see, you give far-reaching judgments. You lay down guidelines, as in the case of Kedarnath Singh in sedition.
Yes, sedition.
All right, but you don't follow up whether your guidelines are being followed or not. So this question of implementation, actually that's where the contempt of court is, when your guidelines are not being followed, not because X or Y said some two phrases about you.
Yes.
It's the fact that you have given specific guidelines. In the case of sedition, if the hearing is on the 5th, I do not know whether we'll get a chance to speak, but anyhow, you see the guidelines: incitement to violence, public disorder, breakup of the country, etc. But we have cases, you can go to the Article 14 website, and you have cases in which a marital dispute, and somebody goes to the police and the police puts in sedition also. So bail is then more difficult. The magistrate says, oh, very serious charge, I can't. So
yes.
So also, some chap says that this fellow, he had a motorbicycle and he modified his silencer so that it made a lot of noise, and he went past, and that disturbed my sister and her baby, and so
Sedition.
no, yes, so the police says sedition.
So they just
And the court is oblivious.
Yes.
So why don't you get together with young people, with persons who are dedicated to helping you, and say, please monitor such and such thing. We are giving this guideline. Here is a sort of standing watchdog of these 3 persons from the National Law School and from this person's chamber, and they will report to us all cases occurring, and everybody filing a sedition case will report the case to them and send the FIR,
Yes.
send the charge sheet and the bail order.
So setting up a specific body, really.
Yes, and that body should summarize the data, collate the data, give it to the court, and put it on a website, preferably of the Supreme Court itself.
Yes.
Then everybody knows, every little police officer will know that, you see, my name will be there if I violate this.
Keeping them accountable.
instead of
And you must give very strong punishment to those persons who violate your law, just as in Parliament. You know, on the 50th anniversary of Parliament, a unanimous resolution was passed. Anybody coming into the well of the House will be automatically suspended. Is that being followed? No.
not in
So what is the point?
the breach it's being followed.
So I would urge that even in Bhagalpur, those are. See, that's why I reconstructed these cases to show these lessons,
Yes.
that you have to follow up, you have to punish those. I pointed out that nobody suffered except that poor Das.
Yes, you are.
So the judgment never really ends with the paper. The
Yes,
rhetoric, the larger rhetoric.
it should not end.
It should not.
It should not end with just the fact that you have delivered it and now you go to the next great case.
So, I mean, this brings us to the nature of. There's a lot of times where the court has to intervene in public interest. Sometimes it refuses to do so, but sometimes it also bites off more than it can chew. It becomes a institute of governance itself. So, in a recent interview, I think it was in April of 21, we were doing the research. So, Mr. Salve, he said that from 1991 onwards, the relationship between the executive and the judiciary, because we had such a spree of coalition government, so it was the court that sort of took center stage and became more of an institute of governance. But of late, from the time of Chief Justice Mishra, Gogoi and Bobde, and maybe even today, that the court has become more reticent in taking over cases of public interest. And the most glaring example that we saw was in the case of the migrants during COVID-19. So where do you see, how should the court, balance? It shouldn't be, because sometimes, like as you said you described in the Agnivesh case, the stringing indictments from 86, 87, but it's not really been
bonded labor.
implemented. In cricket also, I think it
And
happened.
poor Agnivesh has died.
Yes.
You are right.
So where is the line where they can actually be effective?
No, I think the presumption of constitutionality in this case, presumption, in my case, is on the side of the judiciary. It is because of the fact that the executive is not fulfilling its duty that the judiciary is compelled to step in. But if you step in, I would think 2-3 things should be done. One, please take greater assistance from experts in that particular field.
Yes.
If it's pollution, as I've tried to mention, that nobody can know everything about the vast range of topics on which the judges have to adjudicate. Therefore, please take the assistance of experts. Everybody would give up everything to assist the court. Second is, once you give a direction, please make sure that you are followed. Because otherwise, people think, "Arey yaar, ye to bol hi rahe hain, kuch hoga to nahi." Chalo, then the administration gets used to that also.
Yes.
They are not afraid of you.
Yeah.
So I would, but on the observation of Salve, that when the governments are weak, the judiciary is strong, and when the governments are strong, the judiciary is more considerate. That is true. It's not a good idea, because many of the excesses are being actually committed when the governments are strong.
Naturally.
During the emergency and the Supreme Court caving in, today in this undeclared situation, whether as the environment, look at the judgments of the Supreme Court on the eloquence with which they have spoken about the environment or the need to protect it.
Yes. Where is the implementation?
Yes, and today the environment rules are being diluted one day after the other.
Post facto, prior.
Yeah. And the judiciary looking the other way. So, I think it is very. Therefore, when somebody reads that judgment of the Supreme Court, it's the long judgment by the Chief Justice who became, the Governor of Kerala, quite recently. Now, that judgment is then people will say, "Arey, wo to bol raha hai, bolne do." You go on diluting the law. So, first take assistance. We presume that you are coming in because the executive has not done its job. But please take assistance. And secondly, please make sure that your guidelines and orders are obeyed. And third, please do not be selective in the cases that you take up.
Yes.
After all, if electoral bonds are not taken up, or Article 370 is not taken up, and then when you take up something, people presume you are doing it, you are crossing the election rekha of the executive.
Yes.
Because you did not take up things which are really mountain sized.
Elephants in the room.
Yes.
Yes.
Yes. So we'll go back to the relationship that the courts have with the press. But in your book, you state, I mean, in the 80s, there were various run-ins that the Express had with the government of the day, and you quote, you quoted many colorful anecdotes from Mr. Goenka, but this was a more serious one where he says that when there was very dire situations, you quote him saying that abhi courts.
अभी कोर्ट्स है कि अभी हथियार छोड़ने की the occasion to put down your weapons is not yet, because the courts are still there. We can go to them. That was his faith, and that faith was born from, actually speaking, I'll tell you, it was born by his experience in the 1940s and 30s in front of British magistrates.
Yes.
Yes. That he would have run-ins with the governments at that time, but he could always go to the court, and the little magistrate will act independently.
But how would you characterize the? I mean, I know that on the 5th there's the 124A challenge, but the present role the courts have taken in protecting the press I mean, we had the Vinod Dua judgment, which read down sedition.
No, it only reiterated the Kedarnath case. That whatever was said by the Supreme Court, we stand by that. More or less, it was that.
But even in the, I think, while the
and they said that yes, the journalists would have special protection, should have this, that, and the other. Yes.
But I mean, more. I mean, from my memory, it was, I think, Justice Dhananjay Chandrachud's judgment in the case of Arnab Goswami, when he was arrested in Bombay and wasn't getting bail, and he finally got bail. But that is the approach the Supreme Court is giving. I mean, in terms of protecting the rights of journalists.
Yes and no. There are so many journalists who are languishing, and the Supreme Court has not done something. In the end, when you do it for Arnab Goswami and you don't do it for others.
Yes, there is a.
For this Navlakha.
Yes.
Well, in that case, people will presume that you are doing it because this Arnab Goswami is close to the government and Navlakha is fallen afoul of the government. See that, then you would have to wash off that stain. So why not be even-handed?
Justice has to be seen.
Absolutely, balanced scale.
Right. There's one question going back to journalism, which is headline jurisprudence. Basically, how one or two rather catchy statements from a big judgment is taken up and celebrated. It often changes the whole public narrative. That kind of affects the later on precedent value that it has also. So, as a journalist and someone who's written so much, what can young legal journalists learn from you in avoiding that, in finding the whole crux of the judgment rather than the 2 or 3 more flashy statements?
Yes, and actually to read the whole judgment.
But in reporting?
But what's the problem in reporting? Why make reporting so superficial?
Yes.
Don't be a reporter in that case. If that's what your editor says, don't worry, chota karo, just give me the headline, then don't do it. Why kill your soul and your professionalism just because of somebody else's whim, or he wants only a 500-word statement? Then find some other forum also. Write here for your paper reporting the main, let's say, the outcome. But in analyzing the judgment, why give up such a pleasurable task as scholarship?
Yes.
So analyze the judgment and find another forum, or keep analyzing. When you have analyzed 15-20 judgments, you will see patterns and write a little book about it. So there are other things to do rather than to succumb to mediocrity.
Yes.
And superficiality.
Yes, indeed. And another question, which is on this recent contempt of court filing that you had done with fellow amazing famous journalists, N. Ram and everyone last year.
In Karnataka High Court, yes.
So you'd given this word of the chilling effect that this particular section has on seeing contempt. Can you please elaborate on?
Well, actually, there's a phrase of the court itself.
Yes.
That assaults on the press, apart from the particular case or the particular journalist or newspaper which may be affected, it has a chilling effect on the profession as a whole, and therefore on the ability of the society to learn what is happening, and therefore they will look promptly and firmly at assaults on the press. But in the case of the criminal provisions on contempt of court, that itself has a chilling effect on many journalists, or at least it becomes a rationalization for not pursuing the matter in detail. So I would therefore plead that take away the criminal portion. Yes, there should be contempt of court thing.
So now we can switch to going back to earlier books that you had written on the law. And the first one that I read, it was a week ago now, titled Anita Gets Bail, which was written in 2018, and it's a series of essays about Sir's personal experiences as well as observations about the judiciary at all levels. and you should read it to get an idea. But there's one chapter which was particularly interesting to read because it was written in a lighter vein, and it was titled Eloquence, wherein you put across the point that judges needn't be overly verbose in writing their judgments, and for there to be clarity, they should pithily put across their points. And in the introduction, you recount an anecdote that you had gone to meet Justice Krishna Iyer, the famous Justice Krishna Iyer, whose judgments everyone is taught that you should learn English from these judgments. But you had a very interesting anecdote. So if you could recount that anecdote, and as well as the larger point about judges being more.
Of course, the words overly verbose are your words, not mine, I hope. Because that's not what I said.
The question.
Yes, I didn't say that. But yes, you see, what happened was, as you know, Justice Krishna Iyer was one of the most important judges. Like Justice Subbarao dissents, similarly Justice Krishna Iyer's empathy for social ills, for those who suffer because of social ills, is exemplary. So what happened was that after Mr. Jayaprakash Narayan had passed away, from the People's Union of Civil Liberties, we had organized an annual lecture in his memory, and Justice Krishna Iyer was to be invited, and so I was the General Secretary of PUCL at that time, so I was to go and meet him. And he was sitting in his dhoti and his kurta in the veranda. I still remember the house, and he saw me. He said, "Hey, Shourie, come, sit. I'll just finish dictating this judgment, then we'll talk." And he had with him 3-4 dictionaries and a thesaurus also. So he would, and he had such a fine memory. He would dictate the whole argument that will be going on. Then he'd stop for a minute. He will look up the thesaurus, and I'm sure choose the most arcane word. And I was not the only one to remark on this. In the first edition of the Constitution of India, Mr. H.M. Sirvai, he had a chapter, an annexure on Justice Krishna Iyer's English. I don't think it's there in the subsequent editions, but it was there in the first one. So that is certainly the case of long words, but now, of course, some things are incomprehensible, like this gentleman from Himachal Pradesh, and he has continued to write the same way, and why he has been inflicted on us Punjabis. He has come now to the Punjab and Haryana High Court in Chandigarh, I think.
Yes, recently, even in LiveLaw, we had a few of the judgments with very tough words. So we itself provided little annexures of what these words mean with their definitions.
And you see, a good contrast is the judgments of Justice of Lord Denning. 2 pages, half a page, 6 pages. And he changed the course of law.
Yes.
The course of law was changed by him. And the only citing, what is it? In our case, these words is one thing. You are absolutely right. But in the other thing is, in such and such case it has been said, in such and such case it has been said, in such and such case. It's just cut and paste from the earlier judgments. And now with everything being on computers, it's so much easier to get those paragraphs. But the paragraphs are saying the same thing, whether in one judgment or the other.
Yes.
In Lord Denning's judgment, you will see if there's a quotation, it's from Magna Carta, 2 words.
Yes.
So, from the 17th century, from the 18th century, that's learning, that's depth. So, it should be as brief, as straightforward, and I'm the last person to say it because I'm always accused of writing too long things. But as I am not a judge, I should be allowed to write long.
You're an
and the judges should be direct and simple. That is more important today than switching to regional languages and so on, which is the current issue that is unnecessary.
So another one of Sir's books is called Falling Over Backwards, which is a strong indictment of, I think it's a very strong opinion that has professed on reservations. And at the outset, you quote this letter from
Panditji.
from Pandit
Yes,
Nehru,
yes.
which is from the 27th of June 1961.
Just before.
And,
yes,
just before. And I mean, the context to his letter is that, I mean, we're not even 15 years independent, and that the constitution was built around for individuals seeing the horrors of partition, where community rights were given preferences. So the quote that he says that if we go on for reservations, either on a communal or on a caste basis, we swamp the bright and able people and remain second and third rate. But you further
And this way lies not only something but disaster.
correct.
Yes.
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 Not only folly but disaster.
Not only folly but disaster. Right. So
You-
well put.
yeah. So in the book, in essence you state that neither was Mandal very well thought out, because it was based on data from the last census, which was conducted in 1931, I believe.
Yes.
Nor has it been very. Instead of the amorphous lines of caste, it has sort of solidified particular identities and groups, and so it, in a way, from the inception of the nation, where it was defined as individual identities. Madhav Khosla, in his book India's Founding Moment, has very nicely put this across. But today we've gone back to that group rights.
Not only group rights, but you see, supposing the groups were defined by economic criteria, well, that will be group, poor and not so poor. But if you define them by a retrograde institution like caste, then naturally something which was being erased by modernization, you are fortifying it, and the result is what the person, Mr. Desai and his group, his committee in Gujarat, they had forecast this will lead to a race to the bottom. Everybody wants to be recognized as backward, and that's exactly what has happened.
Yes.
Upward Marathas and now
Yes,
Gujarats.
everybody is saying that. And every politician naturally bends to that wind because he gets that little clutch of votes. I remember this, I have quoted it in this book, in the new book, an exchange in the cabinet meeting. Mr. Bajpayee there was an election coming up in Rajasthan. And during an election speech, Mr. Bajpayee was very, alert to these things. He had said, "Ki nahi, Jats ko bhi reservations hongi." He had made that promise. So in the cabinet, somehow this matter came up, and I gave my little arguments against this. And Atalji listened to me. He was very kind to me, and he would let me speak. Then he said, "फिर तो मुझे इस पद से इस्तीफा दे देना चाहिए." So, but that was not the reason that I brought it up, but that even politicians like him would have to succumb to this race of looking around, kisko backward banaye, so that I can get this kind of vote. And those groups are really not backward, they are not deprived, they are the dominant groups. They are the groups,
Number-wise.
well, in power. The Yadavs. If you read Mandal's report in the annexures, and you see the list of atrocities committed on the absolutely poor people, on the Dalits, they are from the backward castes. Mandal's own report says that the funds for development that have been released have been cornered by whom? No, by the backward castes, because they are the powerful people in the area. So it's not that they are deprived, and some politicians saw, oh, these poor fellows, therefore let me recognize them as backward. It is now that they became strong enough to demand and ensure and wrest the label of backwardness. So that is the point that is put down, is documented by evidence.
Yes.
And now, that does not, I am all for assistance, but positive assistance. Supposing the social or economic group, they are living in inadequate housing. So the child does not have a place to read or study quietly. Okay, provide dormitories, provide study rooms. He does not have money for buying uniforms or buying textbooks or laptops or tablets. Provide that assistance. He does not have money for tuition. Okay, provide free tuition. All positive help. But when a competition starts for a job or for the next college, for anything, everybody is equal at the starting point.
But sir, changing this ground reality, this question of giving free laptops in a country of India's size, how far is that dream actually possible?
But just see what Mao accomplished in China. That's what Professor Amartya Sen, Professor Johri, they have been pointing out. That in health, in education, in a society in which the per capita income, even in 1980, forget 1949, when China becomes independent, or this independent means this state of the communist state is formed. Even in 1980, their per capita income was less than ours. But they have accomplished that revolution. But if we are going to have only, if our index of progress is the bigger automobile or automobile production and so on, and not the number of schools or the number of graduates or the patents that we have been able to acquire, then naturally we'll fall behind. Then it is difficult.
Yes.
But otherwise, a society of our size and our resources certainly can meet the aspirations by positive help. But because positive help is not being given, you want to show, oh, I'm doing something for the poor. And what are you doing? I'm reserving jobs.
And actually, government jobs are like a minuscule, less than.
Yes. I've quoted there Professor Dandekar, Mr. Madhu Dandavate. We asked him how many jobs in the government. His argument was, no, it's only 1% or 2% of the total jobs available.
Yes.
Then why are you focusing only on this?
So symbolic. But the government has got this 103rd amendment where they provided 10% for economically weaker sections.
But you see, that is because of the indefensible nature of basing it on caste. But 90% remains on caste.
It's not that goes
and it is only it is a direct repudiation of what the intent of the constitution makers was. After all, Dr. Ambedkar was writing about annihilation of caste.
Yes.
And you are fortifying caste. And yet you keep inaugurating and garlanding the statues of Dr. Ambedkar.
Yes, sir. So we've taken too much of your time, but at last, I think we have a very good question, and this will be definitely for the viewers of LiveLaw, which is a majority of students my age. So we're all entering the legal profession, and we're sure with your experience as an economist, as a journalist, you've met quite a few lawyers. What do you think makes a successful lawyer?
I don't know about a successful lawyer, but a lawyer whom I would admire is not the one who would make money, but the one who would have served public causes.
Yes.
And who would not take up a case when he knew that the client was actually at fault. That's Gandhiji's rule. Gandhiji used to tell the client that even when you are on the witness stand, if I feel that you lied to me, I will get up and repudiate your case and tell the judge, I am not taking this man's case. I withdraw from his case.
Yes.
And he did it. And everybody said, you fool, you have no practice. But actually his practice went up.
Yes.
Because then the community realized that if Gandhi has taken up your case, then the magistrate or the judge will know that it is a sound case.
Yes.
Because he has taken it up.
Yes.
So today, unfortunately, in law, as in every other profession, medicine, journalism, money has become the criterion
Yes.
of success.
Success.
I would look very poorly upon a lawyer or a journalist or a doctor who's making so much money and is known for the fees he charges.
Yes.
That's not our job.
Yes. Even in the incidents of the Indian Express, I heard in an interview of yours, Mr. Goenka, he was against giving advertisements behind buses.
No. Once, you see, there was a news item of when Murdoch
Yes.
started his newspapers in England or bought newspapers, he increased his salaries very much and thereby got a lot of the journalists. So I sent this. So he was asked, why do you give this? These are high salaries. So he said, if I pay peanuts, I will only get monkeys. So I sent this cutting to Mr. Goenka. So he wrote on the margin, but if I have only monkeys, should I not give them peanuts? So he was like that. But it was true that the compensation we got and the compensation we looked for was not money, but the freedom he gave us.
Yes. Yes.
So also the lawyers should really not work for money, but for the public weal. And maybe the money, if you take 2 or 3 big cases so that you may have enough money for running your household, and you use that margin to take up public causes.
Yes.
That would be a good lawyer.
Yes.
And that would be a good thing to aspire to.
Yes.
Whether we are in journalism, whether we are doctors, all middle class people like us who are not living on property, but who are living on their skills or their brain.
Yes.
That's the middle class. So they should not aspire. It is the curse of India. Money today. It is not money. This is not a scandal. When I started writing about corruption, I used to write that this is not a scandal. It is a cancer. It will eat up the body.
Yes.
And that's exactly what is happening today. It is so distressing when we hear so and so charges, 1 crore or 40 lakhs or 50 lakhs for an appearance. And these are generally the persons who I know, the lawyers whom I have known, Mr. Sirvai, Mr. Palkhiwala, Mr. Ashok Desai, Mr. Fali Nariman, Ram Jethmalani, all these people worked so hard before they would stand up in court. But I also know of lawyers today who are sort of briefed in the car.
On the way.
On the way. And then 4 points, and then they have their favorite judgments, and they'll somehow bring those judgments in. So, probably, and the same thing would certainly be true of journalists.
Yes.
So, money is the bane, and it is not the index of success. So, please aspire to work for public causes. Please aspire to be known for your great erudition in law, for your integrity, for the fact that the court can rely on your interpretation, on your citations not being partisan, on the fact that when you state a fact, it is the fact.
Yes.
And so I would urge that.
I'm sure that has inspired me. I'm sure that has inspired all of our listeners and viewers.
Thank you.
Thank you so much.
Thank you very much for your time, sir.
Thank you.
It was an honor.
Thank you for coming.